Okay, I see him now. Right, I think that's all the parties I was expecting. So good afternoon and welcome back to our final of our planned oral sessions for the conjoined wind farm proposals at Craiginmoddie, Carrick and Knockcronal in South Ayrshire. And this session is the reconvened conditions hearing to discuss the aviation related conditions. So I apologise in particular to the council for changing the start time. I hope that hasn't caused any inconvenience. And I'm sorry that the rest of us haven't had a very long break between the inquiry and the hearing, but at least the issues are fresh in our minds. So as you hopefully will know by now, my name's Rosie Levin and Mr Bray and Mr Reid, who are also on today's call. We are the reporters that are appointed by ministers to report on the three proposals. I'm hoping that everybody can hear and see me okay. I can certainly see all of you. So today's discussion will be based on the latest set of draft conditions, which date from the 18th of July 2023. So that reference is CD 16101, and I hope you've all got that in front of you today. Otherwise, the numbers will all get very confusing. And I hope you also have a copy of today's agenda. You should also by now have a copy of the Sankar 2 decision, which has been circulated, I think, over the last hour. And you should also all have a copy of the proposed aviation condition, which the airport circulated last night. Can I confirm that everybody's got all of that?
Yes.
Mum, we don't have the Sankar decision. I've just spoken to Mr. Callan and he doesn't have that.
Okay, I'll ask Mr. Bray to make sure that somebody forwards that to you, and hopefully it'll appear.
I think, ma'am, it's actually document CD 827. We think it has been lodged already.
Okay.
If it's lodged already, then we've got it. I'm sorry, I just assumed it was something that had produced.
Okay, that's fine. If everybody has it, then that's good. So I think before we go any further, we'll just, there are a few different participants this afternoon, so we'll just go around the parties and I'd like to hear who's participating this afternoon. So starting with Craiginmoddie.
So yes, David Hardy, then say partner at CMS, and Mr. Briggs, Mr. Michael Briggs from Energy Contour is on the call as well.
Thank you. Carrick.
So Ewan McLeod, solicitor with Shepherd and Wedderburn, and I have someone else with me this afternoon who will introduce himself.
Yes, good afternoon, Madam. Columnist from Shepherd and Wedderburn. I will be speaking just to agenda item 2, and Mr. McLeod will be dealing with the balance of the agenda items. Thank you.
Okay, thank you for joining us. Knockcronal.
Good afternoon, ma'am. Gary McGovern, partner with Pinsent Masons, representing the Knockcronal applicant. I am joined in this call by Mr. Andrew Yates, who's responsible for aviation matters at Statcraft.
Thank you. Your volume's not particularly high, Mr. McGovern, but if there's a problem as we go along, I'll let you know.
Apologies, I will try to project my voice.
Thank you.
Shout if you can't hear me.
Okay, thank you. And the airport? Sorry, Mr. Finlay, you're on mute.
Good afternoon, we're now a gang of 4. So my name's James Finlay, King's Counsel. To my right sits Ewan Brown, advocate. To my left, Steve Thompson. To his left, Zoe Kilpatrick.
Thank you very much. And the council.
Ma'am, good afternoon. My name is Douglas Armstrong. I'm King's Counsel, instructed to appear on behalf of Ayrshire Council, and I'm here today with Steve Callan, planner at Stantec, who is representing the council as well.
Okay, thank you very much. Am I right in saying there's nobody else participating today who's on the call? No. Okay, thank you. And for those who are participating, it would be helpful we just keep your video on and mute yourself until you're speaking. And perhaps each of the leads for the party could unmute, but for the others, if you could just stay on mute at as we go through until you're speaking. As usual, today's session is being webcast live, so I'll need to read out the usual provisions. So by taking part today, you're consenting to being filmed and for the use and storage of those recordings as we've previously outlined. So today we're going to be working through the aviation related conditions as set out in the agenda. There will be an opportunity for other matters to be raised at the end of the session, although we don't intend to go over any ground that we've already gone over on the other conditions at our main conditions hearing in June of last year, other than in exceptional circumstances, such as a substantive change, for example. And we only plan to raise one small matter around compensatory planting under item 4B. At the end of today's session, we'll also set out the approach to the closing submissions on aviation and conditions, and we'll also pick up with Mr. Hardy on the matter of expenses. And in terms of timings, we intend to complete the agenda today, and we will take at least one short break during the afternoon. So in terms of process, just to remind the parties, it is a hearing session rather than an inquiry, and therefore it's a discussion I'll lead based on the agenda. We don't require any formal presentation of cases or any cross-examination. And as I go through the agenda, I will make sure that parties have enough of an opportunity to comment, and I'll bring in all the others as well. And this may generate a bit of discussion or other questions, but as we go along, please direct your questions through me. And please let the other party finish their point, and you can either put your hand up or speak for real when you want to come in. Are there any procedural questions then before we begin? No, okay. So item 2 on the agenda, we're looking first at the matter of aviation lighting. And as you see, the agenda groups the aviation lighting conditions together and then the other aviation conditions, just so we're not going quite in number order in terms of the conditions list, but it makes sense to do it that way. So we're looking first at condition 5 on aviation lighting, and that's the condition that relates to the Carrick proposal. So I just want to say thank you to the applicants and the council for comments on the minister's decision on the Narrackan application decision. Sorry, that wasn't directly relevant to the airport, so we didn't request comments from them. But I also flag here, obviously we've accepted that late document last week that Carrick flagged, which is the CAP 764 consultation. We have touched on it a little bit in the inquiry session, and that's now CD 11.278 in the core documents list. So we can pick up a little bit on what that document says and what weight we should give to that, but also just to get into more detail about the steps towards implementing an ADLS system. So if we look at paragraph 3.2 of CD 16 1.124, which is so this is Carrick's response on the matter of the Narrackan decision. So if we look at paragraph 3.2 there, the applicant there is saying that the extant regulatory regime allows for the deployment of ADLS technology in Scotland. So we just want to be clear on this. So are we right in saying that the regulations would currently allow for ADLS to be used, but that it would still require the CAA to agree a specific airspace change proposal under CAP 1616 for a permanent TMZ? And that will not be achievable until after the completion of the trial at Mark Hill. Mr. Innes?
Yes, the position is that it's the applicant's position, and has been throughout this inquiry, that the current regulatory framework is sufficient to encompass the delivery of the ADLS. And in that context, that derives, first of all, from the Air Navigation Order, Article 222, which I'm sure you're relatively familiar with. But effectively, that is the document, or that's the provision which requires the lighting, but it's also under subparagraph 7, the ability of the CAA to agree variations to the requirement to have the lights on permanently at all turbines on nights above 150 metres. And I think probably helpfully our original document, CD 011.005, which is the original aviation lighting report, that effectively in section 2 of that we set out the regulatory framework and the fact the effect that essentially this provision derives from international obligations, and therefore it sets out a framework. Article 222 provides that framework, and in terms of the ability to derogate from the requirements, that sits with the Civil Aviation Authority. Against that background, in terms of delivering an ADSL, it requires, in the first instance, either a specific derogation, which would have been one way of dealing with it, or rules relating to a derogation under Article 222. That would have essentially dealt with the fitting and specification of the ADLS equipment. But associated with that is that for it to work in terms of the type of ADLS that we're proposing, there also needs to be a mandatory transponder zone. And that's dealt with through airspace change. We've set out that not only has the regulatory framework potentially being changed in relation to the specific derogation under Article 222, but also CAP. The CAP on the airspace change has also been recently changed because of directions from the Secretary of State. So we've got two sets of rules or provisions that are in the provision of being altered, and CAP 1616 is now to draw a more proportional approach to airspace change. And that's important in that it allows essentially the process to go quicker, where it's more simplified and there are fewer issues engaged. So a proportionate response and one which directed by government. So we've got, at the moment, the regulatory framework exists, and what we have at the moment is the bit, what does CAP 764 deliver? The draft of that is proposing a change because it's providing the specific route to derogation rather than having a one-off set of derogations dealt with on a site-by-site basis. So in that context, that's a very helpful advancement. And I should say that we have also illustrated at CD 011.250 that in the offshore wind sphere, it has been relatively common for mandatory transponder zones to be required as part of the mitigation around aviation interests offshore. This isn't for aviation lighting, it's for dealing with other aviation-related matters. But there are offshore schemes in and around Scottish waters which have had to be supported by mandatory transponder zones, and those are reflected in CD 011.250, and it's towards the back of that document you'll find a heading which was heading up called En Route Transponder Mandatory Zones, a series of English wind farms, and then it reaches the Scottish ones over the page. So in the Murray Firth, Knockcronal and Seagreen have all had to progress with mandatory transponder zones as part of the delivery of those projects. So airspace change and the delivery of renewable energy projects have already been conditioned and seen as part of the potential regulatory framework. So what the sea change would bring about in terms of the revisals to CAP 764 is effectively that within that document, what the CAA have set out is a particular approach to fitting ADSL in UK airspace. And it sits within a section whereby it's dealing with, in Chapter 4, the onshore wind turbine obstacle lighting and marking. And it not only deals with ADSL, but also you've heard quite extensively about the reduction in lighting and not every turbine having to lit, etc. It's now putting those rules in place, and then goes on specifically in terms of paragraph 416 onwards to set out what's required for an ADLS system. And essentially, it deals with the situation that where there is no mandatory requirement to fit a transponder, then you would have to produce or go through the transponder monitoring process at 421. And in terms of going on, at 425, the CAA will not approve the installation or operation of ADLS, nor undertake continuous regulatory oversight of such systems. And effectively, it then sets out a proposed specification that an ADLS would have to operate. And that takes the approach a step further than perhaps was anticipated. In some respects, it might have been one where it was approved on a one-by-one scheme basis, but that's not the approach that CAA proposed to take. They proposed to set standards, and thereby it is for the essentially the promoter of the scheme to procure equipment which meets those standards. So in terms of the regulatory process, each part of the regulatory process is changing, and it's all changing in favour of being supportive of the delivery of ADLS, both in the context of the equipment itself, but also in facilitating airspace change, which is the caloric part of delivering the condition itself. And so, again, in terms of where we were, and I think it's quite important to where we were in terms of the evidence before either Clockery document 826 and the findings of the Scottish ministers at paragraph 13, or Narachan, that effectively that position has moved forward. And in particular, if we look at Narachan paragraph 119, it's clear that things have effectively moved on, and we can essentially say that effectively the evidence is different from that which was led at that particular inquiry. So in terms of that, sets out the broad parameters of how it will work, and I'm more than happy to say how it fits with where our evidence is at, if that would be helpful, Madam.
Okay, we'll get on to that. So in terms of the weight that we should give to that consultation then, what's your view?
Well, my starting view is the regulatory framework existed before the consultation. What this does is essentially support the evidence that we gave at the time and have given throughout, that essentially ADLS systems are now sufficiently far advanced in the technology and trial elsewhere that effectively the CAA is saying, rather than test it on an individual basis, what we're keen now to do is to promote a technology where it's a specification-based approach, which shows even more confidence in the technology than saying that we might accept, a technology on a one-off basis on a case being made. So essentially, what you're seeing is the CAA actually on this draft saying they've got a lot of confidence in the technology, and I think that's the key point. That's the difference that I would say exists from the evidence that you heard last year to the evidence that we now have because of that document. It's that particular position that has changed, and it's that one which I think is very helpful. But even if it changed, what we see is the specifications being set out, and even on an individual basis, we now understand what it has to meet, and these are, as we understand it, related to those international standards, which are being met in operationally elsewhere where this comes to be considered.
Okay, thank you. I mean, I don't want to spend a lot of time on this sort of regulatory framework before we get into talking about the more specifics for Carrick, but does any of the other parties want to say anything or add anything to what Mr. Innes has said? If you agree with him, that's fine, but if there's anything that you disagree with, would you like to come in? No? Okay, so in terms of the specifics about Carrick, you say that the trial plan was submitted to the CAA in March, and I think that's to require the transponders for a period of 6 months. So is that trial plan now approved, or when do you expect it to be approved? And if so, when does the trial itself actually start?
Right. As I understand the position, the equipment has already been installed at Mark Hill, i.e. the ADLS equipment has been installed on the requisite turbines there. The second part of the process is that we require certain data from NATS, which we require on data of flights in order to finalise matters with CAA. That the best description of when that information is likely to come is imminent, is how it's been described to me. And once that information is obtained, it's likely that the trial would be able to proceed relatively swiftly. And so certainly in terms of process, it's anticipated that it will be this summer that it becomes operational. That's the anticipation.
Okay. And I think separate to that, you're saying that a permanent TMZ for South West Scotland has been initiated with CAA. And
yes.
So, and that would be for all aircraft up to what height then?
It's still to be determined, I'm advised.
TBC, okay.
Yeah.
And you say that that approval process would start at the beginning of next year and complete in 2027, you think?
Well, the process has started. That's the key point, that there is, as part of airspace change, there's a number of processes that to be gone through, and one of them's the initial stages with CAA, and they have been undertaken. And equally, part of airspace change is also consultation to make sure that we understand where concerns might lie or issues might lie, and that also has commenced. So it's not a question of us starting next year. That process of building the understanding of matters has already commenced.
Okay, and we heard a little bit during the inquiry about the potential opposition that may come towards that. So, I mean, are you still talking about that process being complete in the first quarter of 2027 then?
Yes.
But presumably through that, is there as that's all going on, is there a formal role for the CAA in signing off the outcome of the trial before you then can get to the sort of next stage? Or
well, the CAA will probably we will analyse the results of the trial and present it to the CAA, and it certainly will probably be part of their overall consideration, given that the regulatory framework's developing. So they will be keen to understand and see the results of our trial as part of that process.
But there's a number of uncertainties within that process. And so I think it's just to ask you again what certainty you feel you can attach to getting that approval at the early 2027 date.
The first point is there's nothing that's come up from the consultations that we've done to date that have shown that there's anything that would be an impediment to the process going forward. That's both with the consultation with other aviation interests and also with the CAA. And that's the important point, is the CAA are very positive about what's being proposed. And I think fundamental to this is that there is no way that the CAA would put out a consultation document in the terms that it did on CAP 764 if it hadn't done due process and understanding the nature of ADLS technology, the specification that was likely to be required to meet their requirements for safety. And therefore, I think this has moved on considerably. Those are key decisions that have been taken. And it does need a project to take it forward. It does need a real project. And this is where, if I'm saying in addition, we have to set out why, and we have set out in our environmental statement why, in Chapter 5 of the Landscape and Visual Impact Assessment, paragraph 13, and Appendix 13.4, we set out why we have embarked upon an ADLS, and that is to mitigate significant environmental effects. We took the view during the design of the project and the preliminary assessment that the only way in which we would mitigate the effects of aviation lighting fully would be through this scheme, and that's part of the justification. So we have to set forward a justification as to why. That's why it is important that we set that out in evidence, and it's very clear as to why we've said it. And I think, if I may also say, that there's aspects of the Narracan decision which also justify that case. Because if I take the Narachan decision, or perhaps the report better, at 828, paragraphs 54 to 73 deal with aviation lighting. Now, as you'll have seen from the evidence that we also submitted, there was a lot of very detailed technical analysis of essentially what can best be described as bulb technology. You know, what were the candela that was going to be seen at particular locations and how bright? And ultimately, the reporter at paragraph 68 of that document said, that's all very well. I've looked at other cases. I've looked at the evidence. But actually, I've been to Ireland and I can see the Ben and Turk 32 candela lights at 13 kilometres, and they're bright and in a dark sky are sufficient to be seen. So in essence, the conclusion was, based on all that evidence of bulb technologies and everything else, the only mitigation that would have worked in relation to that was an ADLS scheme. So insofar as the Narachan decision, I might not like certain aspects of it, which I say are different now because I don't agree with the conclusions regarding regulatory framework. But in terms of that, it actually supports our view of the evidence about the potential impacts of the proposal in relation to distances to receptors and visibility of aviation lights in a relatively dark environment.
I mean, on that, obviously the situations are slightly different, and we don't have detailed technical analysis on the nighttime effects for Carrick because obviously you're relying on the DLS approach. So what do you expect to happen in the situation that ministers continue to not agree with the ADLS approach, given that it's a fairly recent decision that they've made?
Well, perhaps I pose the question the other way. How could the ministers justify imposing a suspensive condition on an offshore wind farm requiring mandatory transponder zone and approval of safety cases relating to various aviation matters, and not in light of the information that we now have in terms of what the CAA has said? And I think that the point is, and I come back, and I will come back, I think, on this point. If I look to the evidence that was put before the Narachan reporters at CD 11-244, and I go to, I think it's paragraph 4 of that document, and that's essentially the applicant's position, having been, I think, given what can only be described as a bit of a hint there might be a problem with aviation lighting. The response was, we don't want to be tied to an ADSL solution for the foregoing reasons. And what that discussed was essentially said that the regulatory position was one about fitting electronic conspicuity to all aircraft. And that was in some ways a regulatory ambition, but one which had been significantly delayed. No, that's correct, but that's not the only way in which ADSL can be delivered. So that was the evidence that the Scottish ministers were given when they reached the conclusion that there wasn't a regulatory framework. There is a regulatory framework. It's Article 222, and it's a derogation. The CAA are interested in delivering this as an ability to deliver mitigation for aviation lighting. But as I say, they were given a certain set of evidence, and if you take that evidence and reach it to the conclusions, that is a very strong part of where effectively the decision got to. But I think it's also important that if you read the tail piece of the actual ministerial decision, the minister's decision in relation to Narachan, is they do recognise that it is a moment in time. And I think if one looks at CD 0829 at paragraph 119, as such, taking account of the resulting uncertainty of timescales, remember that was the evidence that was led. So we were led that it was potentially reliant on a regulatory framework which included mandatory conspicuity for all aircraft. taking if resulting on certain times of deployment, if it were to be consented, the Scottish Minister consider it would not be appropriate in this case to impose a substantive condition. So it's certainly one where they left open that this was an area that was developing, and it may well be that in other cases it would be. And essentially, against that background, I think it's very clear that things have moved on. And as I say, the 2 points that I say in the regulatory framework, Article 222 and the new cap in draft format, clearly very material, and they also demonstrate the regulatory framework is there, because that's the basis on which it's being promoted. And secondly, the airspace change modernisation, rather than saying there's less certainty about timescales, is actually a whole series of documents directed by government that airspace change is part of airspace modernisation, and we've got to get better and more efficient at doing it. Against that background, all these things are changing to be clearly in favour of the utilisation of ADIS lighting solutions. And yes, we're the first, but we have put the effort in to get to a stage where we are far advanced. And therefore, if one's taken the stage of, would it be reasonable to impose that condition in relation to the Carrick application? The answer is yes, because not only has there been a regulatory framework, but we've actually kicked off the starting point of actually the implementation through the consultation, both with CAA, other aviation interests, to make sure that we can deliver within the timescale. I should say that my clients have a very strong track record of delivering onshore wind consents, and have done so irrespective of the headwinds that have faced the industry, have delivered schemes without subsidy and support, market support. We do have that track record of delivering solutions and delivering the schemes. And it will be likely that it is a company like Scottish Power that is capable to take this forward the next stage, as it was at the outset in delivering aviation mitigation right back at the days of Whiteley. So It is about, have we demonstrated that we've thought about it? Have we demonstrated the steps that we take? Yes. Has our evidence been supported, and have the changes that have occurred support our evidence? And the answer is, in each step, yes, and it makes it more deliverable within the timescales. And that's why these changes are all supportive of our position that we've adopted throughout. And each time it's got better. So yes, I think there's a very good confidence that we can meet the 2027.
Okay, thank you. I'm just wanting to ask if anybody else wants to comment on that. I'm not talking specifically about the details of the following condition, which relates to Craiginmoddie and Knockcronal, but specifically on this, whether anybody wants to comment on the likely timescales or the likely approval for the airspace change. Does anyone want to comment on that? Nothing to disagree with there. Okay. And are there any other challenges that have not been highlighted that we should be aware of in delivering it? No. Okay. So the next agenda items, if we move on to B, C and D, they can sort of be taken together really. So following further submissions, Carrick, the applicants, indicated that it doesn't agree that the council or the airport needs sign off for the lighting mitigation plan. And given the CAA's role in aviation lighting, Carrick considers it's more appropriate this remains at section 36 condition rather than a deemed planning condition. So we just wanted to get to know whether there's any further comments on that from the council or the airport, and particularly from the council, whether you routinely would have planning conditions that require consultation with the CAA. Mr. Armstrong?
And Mr. Callum will address these points on your B, C and D points in the agenda, so go over to him.
Mr. Callum?
Okay, good afternoon, ma'am. Council preference is for any ADLS conditions to be held under the deemed planning permission. Condition 5 is worded, suggests that the council wouldn't be required to be consulted until Scottish ministers consulting the CAA and the MOD. do note that in the Narakan PLI report, CD 8028, that aviation lighting conditions were deemed to be essential to any recommendation approval, but they were included as a deemed planning permission condition, and the council were mentioned to be consulted by Scottish ministers. So I think, yeah, our position is that we will prefer to see them as deemed planning conditions, and for the council to be form part of that consultation.
Right. Okay, any other submissions on that point or any of those bullets? Does the airport want to say anything?
No.
Okay. So if we move on to condition 21, which relates to Craiginmoddie and Knockcronal. So item E, further to discussion at the landscape and visual inquiry sessions and the closing submissions on those matters. Obviously, the council has clarified that it still considers an ADLS condition as necessary for Craiginmoddie and Knockcronal as it is for Carrick. So looking at that item E first, I just want to break that down a little bit. So does the council consider that the same approach to a condition on all three should be taken, same approach across all three, i.e. the condition 5 wording, or are you talking about a different approach for Craiginmoddie and Knockcronal versus Carrick, and if so, why? Mr. Callan?
Yes, our preference is for condition 5 to be replicated across all three proposals. They sit in a similar landscape of aviation will have similar impacts on the Galloway Dark Sky Park, and we would see no reason why there should be a difference between each of the proposals.
Okay, and I presume the applicants will have different views on that. I don't know whether it's maybe better to bring in the next item as well, item F, which is about the consistency of any condition. So yeah, does the council do you have a view, Mr. Callan, on whether clause 2 in the Craiginmoddie condition 21 is helpful or necessary? If we look at 16.101. Page, electronic page 18. I think the suggestion there is that there would be an additional clause setting out the details of the scheme.
Okay, apologies, I was on mute. This in relation to the alternative.
The alternative wording that's been put forward. So it's in column 3 or column 4 it is actually. So obviously there's two different approaches. The first column shows the other two are slightly different from each other and from the Carrick one.
Yeah, it's still our position that we would rather the Carrick condition has been suggested.
Okay, so you don't have a view on the particular wording of those other two options?
Don't have a particular view, no.
Okay. Could I ask whether the applicants want to say anything at this point? The other applicants, Mr. Hardy or Mr. McGovern?
Mark, I mean, you've got the response in writing. That's not changed. So what we've done is propose a revised condition in accordance with the position set out in the written submissions. So that remains our position.
Okay, Mr. McGovern.
Yes, ma'am. Similar to Mr. Hardy, you have our position in the written submissions. Most recently, the written submission, which is CD 16126, and there's been no change in our position.
And obviously, Knockcronal has a slightly different position. You're saying that you don't agree that an ADLS condition is necessary at all.
Correct.
Yeah. And does the council, or indeed any of the applicants, consider that the provisions in the Knockcronal proposed condition, would that actually allow for the installation of an ADLS at a later date if it became practicable? And if so, was there any reason why the proposed condition for 21 and for Craiginmoddie and Knockcronal shouldn't be the same? So my first part of that question was whether the Knockcronal condition as it stands would actually allow for an ADLS to be provided later.
Yes, ma'am. The council's opinion is that the Knockcronal decision doesn't allow for that possibility, whereas Craiginmoddie does.
That was certainly the intention.
Okay. Any other comments on that?
Ma'am,
Yes.
my view would be that the Knockcronal condition does not preclude the possibility of ADLS, because Lim 2 provides for the possibility of an alternative lighting scheme. So it's different from Craiginmoddie in that it doesn't require the position to be reviewed, but I would say it doesn't. Neither does it prevent ADLS.
Mr. Callan, have you got any further comment on that? Would you agree with that?
Partially.
Which part?
I think it's just a little bit too vague, whereas Craiginmoddie has specifically mentioned doing the review period and possibility of ADLS have been implemented.
Okay. Okay, I think that's all we probably need on that at the moment. So if we move on to item 3, so if we are looking at conditions, condition 6 basically. So the draft set of conditions, just first of all, the draft set of conditions indicates that the council had provided comments on the wording of condition 6 and was awaiting feedback from the airport, I think. That's how I read it anyway. Can the airport provide any comments on that now, or have those comments from the council been incorporated into the version that we've now seen? Sorry, the version that Knockcronal has agreed. That's so we're talking about the Knockcronal condition here. Mr. Finlay, was there anything you could say on that?
Sorry, yeah, my understanding was that the proposal was agreed as a letter, which I think is 1678. I personally wasn't aware the council had commented on that.
Maybe the council can confirm that. The way I read it was that there was still an outstanding comment, but I don't know whether that's been incorporated into that letter or not. Mr. Callan?
Yeah, we were awaiting a comment, but I think the additional information has been submitted now covers that.
Sorry, what was the last thing you said there?
The additional information covers that requirement.
That's helpful. And just before we go more broadly onto B, I just wanted to ask Knockcronal whether Mr. McGovern, whether you've got any specific comments on the condition that you have agreed in light of the Sanker decision, particularly on the proposed wording from time to time, which is at the top of the next page. Obviously, you should have that decision now. You know what I'm referring to there. Have you got any particular comments on that?
I have no particular comments to make on the condition that's been proposed by Prestwick last night. We have an agreed condition with the airport, which is the one that's reflected in the schedule of conditions.
That's the one I'm referring to here.
Yes.
Sorry, I'm referring to the one that's green in the table. So are you saying you don't have any comments on that specific wording? No. Okay. Any other comments on A? No. We move on to B then. So the proposed wording for the Carrick and Craiginmoddie condition. So I guess there'll be a fair amount of debate here. So Mr. Hardy, would you like to feed in on your comments on the condition that we've seen coming through last night?
Yes, well, I mean, comes no surprise that aside from those parts of mitigation which we readily accept and have always accepted. None of the other parts of it are necessary, and you've got the evidence on that, and we're going to be submitting. It's pretty clear that you don't. So not required. Object to the condition in all parts. The second submission is as we, what I was looking at in cross-examination this morning. I don't really understand the condition, and how that works. It seems to me to be a pretty material deviation from where the airport has been before. There seems to be confusion between different parts of the airport, whether that's council or witness as to exactly how that works, whether it's a mitigation agreement, whether it's a the mitigation scheme, where that fits into the evidence that the airport gave in relation to its assessment chart. So I think there are problems with the condition in and of itself. The third point is that I suppose this is at the heart of it. There's clearly a lot of disagreement over many years, different parts of different developers with the airport, but in terms of this developer with the airport in this inquiry, there's quite a considerable distance. And what the developer wants to be able to do in order to meet climate change objectives and get on is to have a scheme which can be built. So if consent is approved, that's a matter obviously for the planning balance that you want to be able to get on, as long as the interests are protected. So the condition that's proposed does not allow for a potentially time-consuming and even potentially ultimate veto, which can be run by the airport in stringing things out, never agreeing, getting lost in wind farm mitigation agreements and so on. What we've got is, what's the problem? We're going to pay for that. You have to satisfy the ministers in consultation with the CAA that there is a financial mechanism to pay for that. That's what you do. So it's in just like any other harm. You have the harm identified, you have scheme to pay for that, off you go. You don't need to get any more involved than that. So what we're proposing here, very straightforward. We say that does everything that it needs to do. The condition that is proposed by EK is the same condition that was proposed at Sanka and which was recommended by the reporter. What you then got in from the ministers was an amended version of a condition which actually wasn't the condition that either the developer or indeed the airport put forward. It was sort of somewhere in the middle ground. The difficulty with that is you get back into the tangled web, and I do have for the developer who was acting in a Sanka, as you know from the papers. I could still continue to do that. You just head back into the morass. So we are proposing the condition that we proposed at Sanka, recommended by the report, in which we say deals with those interests that need to be dealt with, and then once that's satisfied and paid for, we can get on. So that's our position.
Mr. McLeod, do you want to come in at this point?
Thank you, ma'am. Our position is very similar. I mean, we've set out the same condition as Craiginmoddie, which effectively says that we will pay towards the reasonable and demonstrable costs of optimising Terma. And we say, and we'll say in submissions, that the evidence this week has demonstrated that Terma is what's sufficient to deal with the issues. The condition that Glasgow Prestwick have put forward, as Mr. Hardy alludes to, is based on the Sanker 2 decision issued by ministers, and not the condition that was recommended by the reporters. Now, the condition does have some issues with it. One of them, as an example, is that in part 3, there is a requirement to agree a scheme with the airport to mitigate the impact. And I note there actually that Mr. Finlay's clients have removed the words demonstrable impact, demonstrable being one of the things that the ministers had asked for. So quite why that's come out, I don't know. He'll maybe be able to explain. But so far as point 3 is concerned, a requirement to agree a scheme to mitigate the impact on the efficiency of air traffic services provided by the airport operator. Now, I've got no idea what that is, frankly, having heard the evidence this week, and it would be helpful to get an explanation from Mr. Finlay as to what evidence he says supports that requirement. But in summary, so far as radar is concerned, we believe that the condition that we proposed, which is the same as Craiginmoddie's, is reasonable, necessary, proportionate, and all that is required in order to address the mitigation requirements associated with our development.
Okay. I think I'll go to the airport now, if that's okay. You've obviously heard some of the concerns there that have been set out by the applicant. So I wonder if you could explain first the sort of differences between the Sanker condition and the one that you're now putting forward, and say more about how you expect that condition would be purified.
Yes, before I do that, ma'am, can I just pick up something on the Knockcronal? Your last point on Knockcronal was just some misunderstanding, because the condition that's been agreed between the airport and Knockcronal is set out in 1678. It's not the wording that's in green on 16101.
Okay. Right, hang on, please.
It's much shorter.
All right, okay. That's helpful. 1678.
1678. And it's electronic
Right.
page 4.
So that letter is dated the 15th of March 2023, which is before that table of conditions was pulled together, or
Yes,
it was updated, sorry. So why is that not in the table?
Well, if you go to the right-hand column, alongside condition 6, the third entry refers to 1678.
Okay. I see that. So why was that not included in this updated version then, rather than the green one that's there? Is it?
I'm afraid I can't answer that at the moment.
Just the
and we
administrative
apologise. Yes.
oversight.
Oversight, but the Knockcronal applicant and ourselves are agreed as to that wording of the condition.
Okay, can you just give me a second just to...
As I understand it.
Yeah. Okay, so I see that now. So, Mr. McGovern, you're happy with the version that's in 1678?
Yes, we are, ma'am, and that should be the same wording that's in the column in the table of conditions as well. And I must confess, looking at the two quickly, I can't see any differences, so I'm struggling slightly to understand the point that Mr. Finlay's making.
Well, I'm not sure I understand the point either then, because I think we're looking at condition 6, aren't we?
Maybe I'm looking at an older version of the table, but it's 16101.
The version I'm looking at, Mr. McGovern, condition 6, starts with no blade shall be fitted to any turbine. And it goes on over the page.
My apologies. I was working from a paper version and it appears to be an earlier version. So the errors at our end. Looking at it now on the version that I've accessed via the internet, it does appear to be the same. So apologies for that red herring.
Okay. So,
Ma'am,
yes, Mr.
sorry,
Hardy?
if you finish that point, there was just another point before Mr. Finlay comes back on the
Well, hold
condition.
on then, just
yeah.
a second till I take a note there. So what you're saying is that the condition that's in that letter 1678 is not the one that we're agreeing to. That you,
I think they're both the same.
okay, that's fine. Thank you, Mr. Hardy.
Sorry, Mark, I thought you'd finished. I was not being
now?
river interrupted. Right. The other thing that we've just noticed is that the Sanker condition, I think Mr. MacLeod has picked up on the fact that the word demonstrable was dropped, was left out of the first paragraph. So the Sanker condition was in writing by the Scottish ministers in order to mitigate the demonstrable impact of the development upon. And you'll see that the new condition is just in order to mitigate the impact of the development upon. And there was that degree of control. But more importantly, or just as importantly, and maybe more so, when you go to number 3, so on the original, on the Sanker condition, developer has put in place a binding undertaking to pay the airport operator such sums as are demonstrably and reasonably incurred by the airport operator. When you look at the GPA condition, it is have conferred in writing that satisfy the developers put in place binding undertakings in respect to the following matters with no restrictions. So in those two regards, and that of course, just in terms of the evidential base, you heard, well, and this morning, there's a very clear statement from, I think, Ms. Kilpatrick, I think it's in Mr. Thompson's evidence as well, that they understand and accept the Sanker decision is that it has to be reasonable, demonstrable, and so on. So there's two important omissions on the face of the new condition.
Okay, Mr. MacLeod, do you want to add anything before we then go back and hear from the airport?
I was going to pick up that very point, but really just in the context of once you get into my initial comments, I should perhaps have clarified related just to the first part of the condition. We then get into more detailed parts about additional radar feed, optimization of the terma, and additional repeater stations. And the point about demonstrable and reasonable comes up at the beginning of each of those, I think, because what it says is that you're to pay the airport operator such sums as are incurred by them in connection with, and then a whole list of things. Now, such sums could be anything, you know. We'd like some sort of, based on what Mr. Hardy's just explained, we would like some sort of recognition from the airport that the sums that they are looking for reimbursement for are demonstrable and reasonable, rather than, you know, somebody charging £1,000 an hour to come and change a plug.
Okay, so I mean, I'll go back to the airport now. Back to my original sort of question about the differences and specifically those points that Mr. Hardy and Mr. MacLeod have made about those words being dropped from the condition. So if you could cover that, and also just the more general and important point about how we know what those sums would be and what the actual mitigation would be, which is really my initial question about how the condition would be purified. So could you respond to that, Mr. Finlay?
Yes, first of all, in respect of the demonstrable and reasonable, in the drafting, taking that as read, but as Ms. Kilpatrick made it crystal clear this morning, the airport accepts that. So I can deal with that one very easily. If my own friends wish that to be included, that is absolutely understood in respect of each of those. And I don't, that should not be an issue. It's the first time I think the airport has heard that the Craiginmoddie applicant does not like condition 7 of the Sanker 2 the same operator, Sanka 2. As far as I'm aware, Mr. Hardy may correct me, the Sanka 2 condition 7 as approved by ministers, which is clearly the one that should have primary weight. And the first time that, as far as I'm aware, that the condition being proposed is that as in Sanka, as that proposed to the airport by the applicant to the reporters and accepted by the reporters, although that may be clear from a reading of the conditions schedule. We prefer the one approved by ministers. The terminology of efficiency of air traffic services it absolutely mirrors the word provided by ministers, the wording provided by ministers at the end of clause 7.1 Roman numeral 2 in the Sanka 2 decision. The purpose of the clause 3.1 was explained this morning and all this afternoon. Time tends to merge, but to give the option to the operators to provide the feed rather than pay for the feed to be provided. But the airport, on balance, would prefer that the feed be provided and then could simply deal with it. But if it's a question of it providing the feed and having it paid for, so be it. In terms of what is required to purify the conditions, the cost, in our submission, we're no significantly different from the position that faced ministers in Sanka 2, which is perhaps, and it perhaps underlines the omission that the cost should be demonstrably and reasonably incurred, but as I said in our submission, that would be taken as read in any event. But we're in no position at the moment to provide the cost of a VHF repeater station for the reasons that we've outlined. As we made clear in our evidence, there is a real issue. The CAA accepts as a real issue, and we accept that whether that issue translates into an operational issue needs to be determined after testing with the turbines in place. That's, if one reads the hazard assessment at CD 11253, that's exactly the conclusion that's reached there. So you need a form of condition which covers that eventuality. So the airport's not saying it's definite that it's going to be needed, but there's a reasonable likelihood that testing needs to be done, needs to be paid for, and there may be a need for a repeater station. And I note in 3.3 that should say station plural, singular, I believe. In terms of radar feed, in response to your request, we gave some indications of the likely costs over a 35-year period, which haven't been discounted for timings of payments or the like. But the cost of that will depend upon whether it's radar feed is provided to the airport or the airport has to provide it. And for instance, one can usually see that if it was provided, for instance, on the land belonging to one of the applicants, that would be significantly cheaper than the airport having to acquire the land to provide it. So I can't provide you with particular detail on the costs of purification. But what we've hoped to do is provide you with the matters that would need to be dealt with. In terms of the particular criticisms of Mr. Hardy, he his concern was about what a wind farm mitigation scheme would entail. I've obviously heard Mr. Kilpatrick's evidence. The airport's preference would be for an agreement. But legally, and it is a matter of law, a wind farm mitigation scheme does not necessarily have to comprise an agreement. It could comprise a series of mutually interlocking undertakings, for instance, which would be a vehicle, as Kilpatrick alluded to, which could give rise to the same outcome. We've used the words wind farm mitigation scheme in exactly the same on exactly the same basis that the ministers used it in Sanka 2. So it's not enforcing an agreement. An agreement may be the most obvious way to deal with it, but there are other legal options, which, and no doubt, as I understand it, and again, Ms. Patrick alluded to this in her evidence, there's currently a debate going along as to purification of the Sanka 2 condition 7. I believe that and the reasonable and demonstrable cost provision were Mr. Hardy's main detailed points. I think I've dealt with Mr. McLeod's main detailed points too. Suffice it to say that our submission will be, it's pretty clear that mitigation is needed, but that will be a matter for you to determine.
Okay, thank you, Mr. Finlay. I think obviously Mr. Hardy and Mr. McLeod will want to come back on a lot of that. I just want to come in first and just ask around the costs. And obviously, I had a little bit of discussion earlier. We looked at that spreadsheet with all the costs, which Ms. Kilpatrick said were sort of an estimate of what might be required. Is there anywhere else that we can look to see what costs might be covered under this wind farm scheme? Obviously, there's lots of things set out in the condition, but does it include, for example, maintenance of such systems in the long term or upgrades to them, or is it just the capital cost? What, in terms of, from our sort of planning perspective, what are you reasonably including in your requirements?
As I understand it, there is an item for maintenance and support of the system within the cost spreadsheet.
And presumably those costs could go on for the lifetime of the wind farm.
Absolutely, which is why in proposing a radar feed from the applicant or any applicant that is successful, that gives them the opportunity of controlling that cost. So one of the criticisms of the airport at Sanka and Clockery, indeed, as I understand it, was that the airport was seeking money for no, which couldn't be guaranteed would in fact be used. If the radar feed is provided to the airport, then the airport is not getting the money, it's getting the mitigation in basic terms. So that's why that option was presented. If the airport has to provide the mitigation, then maintenance and support will be a part of that. And if an additional radar feed is needed by reason of these wind farms, then in our submission, that is an appropriate head of cost for the applicants to pay, provided it's reasonably and demonstrably evidenced.
Okay, and following on from that, I think we discussed yesterday or the day before about how the costs would be fairly apportioned between the applicants. Obviously, we have 3 applicants in front of us, but if we were in a situation where ministers were only approving 1 or 2 of those, which may or may not include Knockcronal, how do we ensure that those costs are split fairly, or is it expected that that radar feed would then be provided by perhaps just one applicant?
Well, again, that maybe you would want to, in those circumstances, provide a condition that envisaged either a radar feed being provided by an applicant or by the council. If you
By the airport, you mean? Sorry, not the council.
The airport.
Hope the council's not thinking.
Yes, Mr. Armstrong having a heart attack there, I can see. In broad terms, if the wind farms 1, 2 or 3 give rise to the need for mitigation, then as I understand it, the airport accepts that the mitigation should be, the costs of the mitigation should be split between those wind farms which are permitted, and that would include Knockcronal.
Okay, that's helpful. Right, I think I'll go to the advocates. Mr. Hardy, do you want to come in?
Yes, a number of points. One, I mean, I'm surprised to hear about the point about words being dropped and being taken as read. They're clearly important. And if you're going to cut and paste the decision, it feels to me as though there's been active deletion. But be that as it may, they come back in. That is in line with the evidence of the airport. Second point, absolutely, there continues to be dispute in relation to purification on Sanka because of the difficulties that we'd had envisaged. And it seems to us that if you have identified mitigation that does away with the concerns so far as aviation safety is concerned, they're paid for, that should be it. And that is exactly why the condition was submitted and recommended for approval by the reporter. So it's or if you do something else, what you do is introduce the potential for difficulties, the potential for getting snagged, veto, or whatever you want to call it. It's not necessary because the decision has been made. This is the mitigation that's required. Absolutely, pay for it. Away you go. It's no different to anything else. The third thing is that I was a little bit surprised by what Mr. Finlay had to say, because the condition that's been proposed by my client has been there from the outset. So when he said it's the first time he said we're not content with the Sanka decision from ministers, it's absolutely been absolutely clear, no secret from the outset. We are proposing the original Sanka condition because that's what we consider to be sensible, and the reporter agreed with us. The fourth thing, in relation to VHF, I have to say, just listening to the submissions, even on their own case, that doesn't satisfy the tests in terms of necessity and so on. It's a maybe, could be, precautionary basis. That is not the, in my view, even on the airport's case now, not sufficient to justify a condition. The fifth point is in relation to compensation. So it's paragraph 4.82 of the Sanka report regarding ongoing costs.
Sorry, just hold on till I get the report.
So it's paragraph.
Which paragraph was it?
4.82. Ongoing costs, whether that is compensation rather than being a specific mitigation measure, and you can see what's set out there. The arguments that I was at Sanka, Mr. Finlay wasn't. It wasn't just about future profiteering, although that was part of it. It was about whether or not the airport could seek to absorb or seek to extract money from the developer for what were ongoing costs, the costs of running an airport. It's what it chooses to do. That's its business. And what they were seeking to do is include lots of cost, which were not reasonable or reasonably and demonstrably related to the development. And that is what the reporter was policing against, and you've seen in the report. So we think that the costs which are now being sought are very wide. You would have to be very careful about what was included. And the sixth point and final point is this: even now, even on the 3:45, there is disagreement. On the airport's part, we've got Mr. Finlay saying, well, as a matter of law, you heard the evidence from Ms. Kilpatrick. I'm still not sure where we are. I mean, if Mr. Finlay's, he's the advocate. He's saying it does not read to require a wind farm mitigation agreement. So I guess we have to take it that's the resting position. You will have to decide where that fits with the risk assessment flowchart that we've been to a few times over. It's chaos in my respectful submission.
Mr. MacLeod, do you want to come in?
I'll try and not repeat points that Mr. Hardy's made, and I'll try and keep it fairly brief. A couple of points. One, just on that last issue about the need for agreement or not. I may be misunderstanding it, but if you look at the draft condition that's been proposed by the airport, developers shall not commence development until Scottish ministers are satisfied that the developer has agreed a wind farm mitigation scheme with the airport operator, dealing with various things. So I'd understood that the airport did want to have the or did want to impose a requirement that they agreed to whatever it was. So that was point number one. The second point, I heard what Mr. Finlay said about part 3, i.e. the efficiency of air traffic services provided by the airport operator. Mr. Finlay quite rightly made the point that that comes as a direct cut and paste from Sanker 2. We're not in Sanker 2. We've sat and listened to evidence for the last 4 days, and I'm struggling to understand what impact the developments would have on the efficiency of air traffic services, whatever that means. I don't understand it still. So we would resist that point. On the additional radar feed issue, you'll see 3.11A, developers to supply the airport operator with a quality assured radar feed to be delivered to the airport operator for the life of the development under a service level agreement, the terms of which will also be submitted to and agreed between the developer and the airport operator, and then agreed by Scottish ministers. Well, what are the parameters of that service level agreement? This was one of the points that I asked Ms. Kilpatrick about. In fact, the only point I asked her about at the end of her evidence. Are we talking about 90% probability of detection, or are we talking about something that the airport will determine in due course? I don't know, and that does not feel like a reasonable condition to me. And I think those are probably, we perhaps have a slightly different position on VHF, and our position may be slightly softer when it comes to VHF and the possibility of testing. But perhaps the best thing to do on that is if I could perhaps come back to you in writing on that, because it may be that we could come up with a form of wording that would work for VHF.
You mean come back to me or come back to the airport?
Both of you. All of you.
Thank you. So that's just on the VHF wording?
Yes, it is.
Okay. I think I'll go back to the airport. Mr. Finlay, do you want to respond to the matters that have been raised? And particularly, I'd be interested to hear your views on, if we look at your condition, item 1 in your condition, the wording around wind farm mitigation scheme. I mean, it could be replaced with wind farm mitigation agreement there. I mean, it is essentially just the vehicle, whatever you want to call it. Is that right?
Yes, it is a vehicle, but it doesn't. The point, and as I understand it, it's a vehicle to ensure that Scottish ministers have something before them which they can agree to in writing. and hoping to avoid dispute, we thought we'd choose the wording that Scottish ministers used in Sanker 2, which is where they have thought fit to impose the need for agreement. Whilst we're on that, can I take you to the definition of wind farm mitigation scheme? You'll see that it doesn't refer to an agreement, but it does refer to the airport operator having to demonstrably identify various things as necessary. Now, again, so in our submission, there is the wording in clause 1 is appropriate for the reasons that I've indicated. As to the efficiency of air traffic services, if Mr. McLeod's clients and Mr. Hardy's clients are wrong, and that there is a need for mitigation, but the airport cannot provide it, then it will have to direct traffic to avoid the area. That will have an immediate effect on the efficiency of air traffic services. They all follow from the mitigation that, or the issues that we say arise as a result of these turbines in the context that's been explained over the last 3 days. As to Mr. Hardy's points, first of all, in terms of VHF, I'm grateful for Mr. McLeod indicating he takes a softer approach. We can deal with those by.
I should say I may do. I'm not. I've only seen this condition less than 24 hours ago, and it's been a busy day. So my position is we may be back on that.
I'm not going to. Whether the evidence is in such state as fits in with the circular advice and conditions we can make, it's probably best to make closing submissions on. Mr. Hardy now having raised the point, but we say that it does, and indeed it ties in with the question that you asked. The third question that you asked to be enlightened on was whether the effects on VH infrastructure are a legitimate concern for the airport. We will invite you to answer that yes, and then our proposed condition is a proposal as to how you deal with the consequences of answering that question yes. No doubt Mr. McLeod and Mr. Hardy will be asking you to say no to that, different consequences. If the requirement to pay specific costs for optimization, as I understand it, Mr. Hardy does not dispute. If he wishes a similar absolute requirement to pay for an additional radar feed, well, then that is one approach that the airport could live with, provided, no doubt, that the words demonstrable and reasonable were put in there. But in our submission, what the form of condition that we propose provides a more consensual approach to providing a solution than that which Mr. Hardy refers to. Just consider. Yes, the final point he made was by reference to 4.82 of the Sanker report. From my brief reading of it, and Mr. Hardy's right, I wasn't at the Sanker, but my brief reading of it, that deals with a different situation. It doesn't deal with a situation where a specific item is needed for one reason only, that is mitigation. There is no basis as a matter of principle that the ongoing maintenance of such an item, provided it's still only needed for mitigation, shouldn't be paid for those by bringing around the need for the mitigation in the first place. So those are our oral submissions in response to that. Obviously, we'll deal with conditions in our closing submissions as well.
Okay. Mr. McLeod?
2 points very briefly. I may have missed it, but I'm not sure Mr. Finlay dealt with the service level agreement point I raised. And the second point, credit where it's due, Mr. Innes, who's obviously got sharper eyes than me, pointed out that if you look at the definition of wind farm mitigation scheme that Mr. Finlay took you to, I'll just wait until you've got that. So in essence, it talks about the requirement to such services, resources, including equipment, etc., as the airport operator demonstrably identifies as necessary and sufficient to prevent the operation of any turbine forming part of the development impacting adversely on radar performance, etc. Now, wind turbines will inevitably have some adverse impact on radar performance. The question of whether that impact requires mitigation, same for communication, navigation, surveillance systems, etc. The question of whether it needs to be mitigated is obviously one of significance, whereas this is imposed in a way that's an absolute threshold and there is no qualification to that at all. It would allow for any adverse impact to require mitigation, and that's plainly wrong.
Mr. Howard, did you want to add anything before I maybe go back to the airport?
Probably the first time I've heard that the airport would, well, I don't know, potentially suggesting another condition in relation to avoiding wind farm, mitigation agreements. I don't know what the procedure is going to be from here on in, and in particular, given the movable feast, is there going to be another draft condition, or is this it from the airport? What I've heard this afternoon isn't even the final position from the airport. Obviously, I've got notes on what's been said. So is this going to be a line under it, and therefore you just deal with the points in closing submissions, or is there going to be a sort of interim final resting point when the airport has reflected on its position?
I think that's for us, Mr. Hardy. We'll have a think about that. We'll just have a short break in a minute anyway.
Yeah.
Before we go on to the other conditions.
So I think my question, it really depends on that, because I could probably, in response to some of the potential amendments, I can pick them up in closing submissions. I don't know quite what they are yet. That's the problem. At the moment, no, you've got our position clearly set out. If there were to be another draft condition, then obviously I'd like to deal with that. Whether we do that within an interim position or we do that in closings, I don't mind.
Right. Okay. Well, let's pause that for a moment. Are there any other comments that anyone wants to make about this at this point of the agenda, or should we have a short break? Mr. Finlay, you look like you're about to speak.
Just to pick up Mr. McLeod's, or perhaps Mr. Innes's point, the definition of wind farm mitigation scheme is also taken directly from the Sanker 2 decision. I will also note that, but I see that there is a point in I see that there is a point in what Mr. McLeod says, but I believe that is intended to be answered by the definition of wind farm radar mitigation system, which I think makes the point that the mitigation system is to ensure the supply of safe air traffic services. So my understanding, again, I haven't had the opportunity to have time to deal with that point. My understanding is that the mitigation scheme is intended to provide the wind farm radar mitigation system. The purpose clearly is not to prevent any adverse impact at all. As for service level agreement, that's a point I can deal with in closing submissions.
Okay, I think It might be worth just having a short break now. I think there's obviously, we all are suffering from the same issue in terms of not having a lot of time to look at what's come in. So if we could just have a short pause and then we'll think about what we think's the best way to take that forward. So if we could have 10 minutes just now, that would be, thanks. not sure whether anyone can see or hear me, but I'm having problems moving the.
Yeah, I can see and hear you.
Okay, I'm just having similar problems to Wednesday, but hopefully it's coming now. That's worked. I think that's it now. Can't see myself in the corner, but that is a good thing. So we'll just carry on if everyone's back. So yeah, I think in terms of how we move forward, we're conscious that I think we could go back and forth for quite some time this afternoon on just this condition, and obviously the wording seems to be evolving as we're speaking. We haven't all had enough time to consider it. So I think from our perspective, we would be happy if the parties were to go away and try and discuss that with each other, as we did with the other conditions, to see whether there is any agreement that can be made on any of the wording, and certainly get to a position that the airport has tied down the wording that it's been talking about today. And then I think as part of the full set of conditions that we would be expecting to get, we'd be expecting to get a full set of conditions for each applicant in a sort of Word version. And we could still have the comments from the parties within that document or as part of that submission, which would all come alongside the closing submissions. So I think that would give parties a little bit more time to try and see where there's any agreement and to be able to set out your concerns on the airport's condition as part of the closing submissions. Does that sound reasonable, Mr. Hardy?
Well, I mean, I'm not sure. That almost goes further than what I was suggesting. We're not going to get agreement. I can say that. You know that the issues in relation to us are not going to be bridged. What I was after was a coherent, final offering from the airport that we could comment on. At the moment, we don't have that. So the timing really wasn't to ask for time for us to get in a room or anything like that. That's not going to work. But we just haven't seen anything that makes sense from the airport. So if they were able to provide their final offering, that's all I was after, and then I'll make my submissions in closing.
Yeah, but we're not going to get that final position today right now. I think we have to give the opportunity for that to be provided after we close. And whether you get in a room or not, there'll be an exchange between you in terms of seeing that final offering from the airport and you being able to set out where you disagree with that. So that's what we would want to see in the final submission of documents alongside closing subs.
Yes, that's absolutely understood. I just didn't want it to be thought that somehow, you're going to give us a week and we were going to come up with an agreement. Absolutely, that is not going to happen. But at the moment, I just don't know I just don't understand the airport's conditions. So I just like to see the final offering.
All right, okay. And we'll obviously talk about the timescales for all of the closing submissions at the end of this discussion. Mr. MacLeod, are you happy with that?
Yes, I am. I mean, I would echo Mr. Hardy's point. I suspect we'll probably not get to a point where we can agree everything with the airport. There may be some areas where we can tighten things up, but I'm happy to engage over the next couple of weeks and see where we get to.
Yeah, and so that we are clear out of that process where the matters of dispute are.
Absolutely.
Okay. Mr. Finlay, are you happy with that?
I am indeed, and I'm particularly happy with the approach Mr. MacLeod has suggested of engagement, but then working out where we disagree.
Okay. Right, well, on that basis, I think we'll move on in the agenda. So we move on to condition 11, which should be a slightly quicker item. So it's to do with the notification of the airport of a number of matters. So I'll deal with condition 12 in a minute, but in terms of 11 and 13, could the airport just respond on the applicant's suggestion that notification under condition 20 would be adequate? And that's the requirement for 3 monthly updates on construction, notification of the as-built turbine locations, etc. And therefore that no further consultation be needed?
That's agreed.
Great. And on item D, does micrositing have the potential to affect? Yeah, so as the final as-built positions of the turbines following micrositing would be notified to the airport under condition 20. But is the airport suggesting that there's a particular requirement for additional consultation in relation to micrositing under condition 12? Does the different micrositing distances that are proposed by the applicants cause any particular issues for the airport?
Answer that in this way. All we need to know is what micrositing allowance is being made, because that micrositing allowance will be built into any modelling that takes place before the turbines are put up. So yes, but we don't need any further detail. Which will no doubt become clear on any decision. We need to know what the micrositing allowance is.
Right. Okay, I understand the position now. So condition 19 we're on to now. That's the en route radar mitigation scheme. I just want to pick up on the airport's condition, the airport's comment on this condition. And can you clarify, Mr. Finlay, was it that the airport considered that condition 19 should be a section 36 condition and presumably follow on from condition 6? Is that the point that you were making here?
I think our point was perhaps even more basic than that it may have been addressed as number 6 in the section 36 conditions. But I think my understanding is the airport is primarily agnostic, as this doesn't relate to a matter with which it is concerned.
Okay, so it might just have been an ordering matter. Okay, that's helpful. So I think that takes us through all the conditions. So item 4 on the agenda, other matters. Are there any other matters relating to conditions that people think have arisen out of this week's inquiry session? I see Mr. Armstrong's wanted to speak. Are you speaking about the item I'm talking about or the one before?
Ma'am, I'm speaking about the item you're talking about now,
Right.
and
Okay.
although you did indicate it was other non-aviation conditions in relation to what has been discussed this week.
Well, this one is about anything that might have come out of this week's session, and the next item is about any non-aviation.
Well, then I was going on to 4B, so I'll hold my fire until 4B.
That's fine. I'm not sure there is anything under 8 though, just to check that nobody wants to raise anything under that. No. Okay. So, Mr. Armstrong, over to you. Item B.
I'm obliged. It was just to highlight one point that, Ma'am, you'll probably already be aware of, but in relation to the Scottish Government's research into approaches to measuring biodiversity in Scotland, I think certainly when I was last involved in these proceedings, there was some discussion about work being done. That work, there was a draft published in September 2023, and there was a consultation period until December 2023, and that work set out a recommendation which I think is now going forward, and it's just to sort of highlight this point in the context of potentially further guidance and policy coming out in the not too distant future in relation to this matter and the potential requirement for conditions in relation to that guidance or policy, or indeed further submissions on it. And it was just to highlight that point.
But it's forthcoming at this point, yeah.
Yes.
Okay.
That was the point I had to make.
I don't think we have any other major points, and I think Mr. Bray was just going to raise the issue about compensatory planting.
Yes, one very small matter. I don't think it's for discussion today, but just when submitting your final views on the conditions, have a look at condition 30, and for the applicants in the council to be satisfied that that condition will be able to implement the Scottish Government policy on removal of woodland in line with the UK forestry standard. Because that necessitates potentially a larger area to be replanted because it's the productive loss of forestry that has to be replaced, as well as other planting in line with the UK standard. And also for the applicants to consider whether the condition captures the possibility that the keyhold areas may increase or decrease on the back of micrositing or choice of turbine. So essentially, it's a marker for the applicants and the council to consider whether condition 30 will be able to react to any changes in micrositing and fully satisfy the Scottish Government policy on removal of woodland. I don't think it's for discussion. It's really for me to take away. We may have views on that, but it's just giving you an opportunity to just review that condition.
Okay, thank you. So we will move on to item C. So I've already touched on that a little bit after the break there. We would be expecting to receive 3 separate sets of conditions at the end of the closing submissions. I'm hearing feedback. I don't know. Sorry, just a second. Yeah, we would expect to receive a separate set of conditions for each of the 3 proposals, and within that there can still be a column or some narrative around what the areas of disagreement are. But if we could separate them now into 3 separate sessions, that would be sections, and in Word, please, that would be helpful. And I'll talk about the timescale for that just in a second. So moving on to D, closing submissions. So I think we'll maybe deal with the matter of expenses first. Mr. Hardy, do you want to say a little bit more on that now?
I'm not sure what you want me to say. There is, yeah, I mean, it's been telegraphed for some time, and what's happened this week, I think, has just concretised that. It's not been particularly veiled as to where that's going. So that's an application which needs to be written, obviously, and we'll do that. Whether that comes in with the closing submissions or not, I suspect that might be a sensible way of dealing with it.
Okay, so that's fine. We were certainly going to request that it was done in writing, given the timescales. So you would need to set that out, and then the response would need to come at the same time probably as the closing submissions. So could you indicate, Mr. Hardy, what a sort of reasonable timescale for making that case to us would be? Because then that will kind of dictate when the closing submission dates will be.
Because it's the reverse position, you mean, as in you would expect the response to come in with, because of course it would be normally, well, I don't know how you would propose in closing submissions, because you would expect the applicants to have the last word, but obviously there's a response, and it would be the other way round.
Yeah, so if say you took 7 days or 14 days to get that case to us, then there would be another 14 days for the council and the airport to get their closing submissions to us, and then another 14 days after that. So it's really, it's how long that period is at the start before we can start that
14 days, that sounds fine. Also, I think you were going to then allow a period of time in relation to the conditions. So would you tie that in as well? Is that 14 days for the parties to look at tidying up the conditions?
Yeah, so I think on the basis of what you're saying, I mean, if you can do it quicker than 14 days, that's great. But if you think that's what you need,
it's probably what I need. Yeah.
Right. Okay. So 14 days to put in your expenses case. Then 14 days after that, we would expect the council and the airport's closing submissions. And then 14 days after that, we'd expect the applicant's closing submissions.
Yeah.
And so closing submissions will be on aviation and on conditions, and that means all conditions, not just the aviation conditions, because of course we didn't have closing submissions on the other conditions, I don't think. And just to remind you all that following the approach to request summaries of case for the other inquiry sessions that we had on landscape and visual, we'll also request summaries of case on aviation safety. We don't need that for closing submissions on conditions. So that would just be for aviation safety. And the template is the same as you've used before, but we'll send that out again to make sure everybody has that. So I think if we could just have a quick look at the calendar and get the dates right, because that moves things back a couple of weeks. Mr. Ray?
Just to clarify, I think we would be expecting the response on the expenses to come in at the same time as the closing submissions of the party you're making the expenses against, Mr. Hardy. You haven't told us that, but we could guess who, but you might want to see who as well.
Again, the claim for expenses, GPA, yes. No, don't. Yeah, it's not the council. Yeah, I can see Mr. Armstrong. It's no, absolutely not against the council, Mr. Armstrong.
Okay.
I was getting rather concerned there because it's the first I'd heard at any stage.
No.
Oh, sorry, Mr. Armstrong.
Until then, that somebody mentioned the council.
You are suddenly, you sign on this afternoon, you have to provide a radar feed and respond to a cost claim. Probably wish you hadn't signed on, Mr. Armstrong.
Right, okay, so in terms of dates, then that takes us to the 10th of May for the submission of the expenses claim, Mr. Hardy. And then the 24th of May would be the initial date for closing submissions. And then the 7th of June would be the final date for all the closing submissions and the response to the expenses claim and the final 3 sets of conditions.
Can I raise an issue of timings, ma'am? So unfortunately, I'm on holiday from the 24th of May for a fortnight. And so had Mr. Finlay's submissions been coming in on the 17th, I would have been happy to turn around the response to those in a week by the 24th. But if they're only coming in on the 24th with the best one in the world, I'm not going to be in a position to respond to that until at least Friday the 14th of June.
Which,
so my apologies
which is unfortunate. I'm just wondering whether there's any room to shorten Mr. Hardy's initial.
Can I suggest a variation just to help you and matters move on? We can provide our closing submissions by the 17th of May, but I would like the 2 weeks to respond to Mr. Hardy's expenses application. So that would enable Mr. MacLeod to go on holiday with a clear conscience and Mr. Hardy to have our response according to your original timetable.
Okay, so that you're suggesting Mr. Hardy has the 2 weeks to the 10th, and then the airport can provide its closing subs by the 17th. Obviously, we'd have to see whether the council is willing to do that as well, and then the applicants by the 24th. So shorter for everybody, but we get to the ultimate point quicker. Is that?
No, not quite. We will provide our closing submissions by the 17th.
Yeah.
We will provide our response to Mr. Hardy's expenses application by the 24th. Mr. Hardy will no doubt need some time to provide his response to that. I'm not, that timescale is completely between you and Mr. Hardy, but what I'm bringing forward our closing submissions to enable to accommodate Mr. MacLeod.
Yeah,
Very
okay.
grateful for that.
So, Mr. Brave, what?
I think we probably do need to build in that extra little time for the response from Mr. Hardy on the expenses. But I think we will probably set this all out in writing on Monday. Once we've double checked everything, I think.
So I'm sorry we haven't got the final position there, but we know that Mr. MacLeod's not available between the 24th and the 7th. Okay, so the initial step is Mr. Hardy providing the claim by the 10th. So yeah, we will confirm those dates on Monday. We'll also go out to you. I think there's a few updates to the core documents list that have just been sort of flagged up as we've been going along. some of which I've written down. Make sure the Sanker decision's on, make sure that the Osprey letter and the email that we discussed earlier is on, and make sure that the letter of the 21st of September from the airport is on. So there's a few things there that we'll need to tidy up. So we'll probably send an email out with that list at the same time. I think that's everything from our point of view. Mr. Armstrong, would you like to say?
Yes, ma'am. It was just to say that the council weren't really intending on putting in a closing submission. We've obviously set out our points today in relation to the conditions, and we will obviously feed into the next version of the conditions, including dealing with the condition 30 point. But we thought we would probably best do that just by a sort of note attached to either, making a comment on, say, for example, condition 30 or not. But it wasn't our intention to put in a further submission in relation to this afternoon's proceedings, unless you require that of the council.
No, I think that's fine, as long as we know your final position on the conditions as we receive them. So you either do that in the conditions document or in a separate document. Whether you want to call it closing submissions is up to you.
I think our preference is to do it in the conditions document, so it will be a sort of note to that.
That's fine. Okay, any other questions or issues that people want to ask? No, I haven't quite believed that we might be at the end of what's been a very long day. So I just want to say thank you all very much for your participation and patience throughout this rather long process that we've been involved in. And following closure of today's session, we intend to obviously as swiftly as we can complete our part of the process. So I'd just like to say a massive thank you to the IT colleagues, Lucy, case officers, Morag and Chris, and the others in our team, and also thank Keith and others on CMS who've taken on the task with the core documents list, which has been probably one of the biggest. So thank you very much to them. So thank you all very much, and enjoy your evening and your weekend.
Ma'am, can I thank you, I think probably hopefully on behalf of us all, you and your two colleagues, for sitting early and late as appropriate throughout the course of the week. We certainly appreciated getting through it all. Thank you.
Okay. Thank you.
Thank you for that. Thank you.